So that previous session went over, but Martin and you guys, feel free to go into the networking break. Take as long as you want. It's the covert discovery of hidden assets.
20 after.
An open discussion about measures used to surreptitiously and legally discover concealed wealth and to attribute it to wrongdoers or wrongdoing. We have, starting on your right, we have Ruth Promislow, a partner in Bennett Jones. Then we have, on the far left is Matt Lindsay, a partner in a new law firm, Rose LLP. And the next on the right is Martin Kenney. Oh, sorry, Ed Davis. And then of Astigarraga Davis, next to him is Martin Kenney of Martin Kenney & Co.
Great. Thank you. Thank you, David. My name's Ed Davis. I'll be moderating this panel. This is interesting. It's going to be hard to top murder and the discussion that just occurred. It's or alleged murder. It's a very serious topic and hard to follow on to that. This is also, in its own way, a very serious topic and a very difficult one to cover in an hour. It's virtually impossible. So what we're going to try to do is hit some of the key issues and then obviously we're all here for a couple of days. We can talk about this stuff in the breaks, but we want to at least tease out discussion on each of the key issues. And we want to do this in a somewhat programmatic way with each of the speakers engaging in somewhat of a conversation with each other and with you. We'll hold questions to the end, please. We'll try to leave time for questions. But let's start out, since we did start late, let's get right into it. One of our first questions we've asked ourselves when putting this panel together was, what is the function of an asset investigation, and what are we trying to accomplish by it? We can't really focus on covert discovery of hidden assets until we understand the function. And in our discussions, we realized that we have multiple functions for an asset recovery plan that is predicated on finding hidden assets in a covert fashion. So first, Martin, I'd like you to cover off what one of the functions is of an asset investigation.
Thanks, Ed. Very quickly, I would say the key words are location of value, represented by assets or rights to things of value, location, defining the manner of holding of things of value. They could be tangible or intangible rights to property. So locating, defining the manner of holding, in other words, what kind of holding structure holds the legal title to a thing of value. And then thirdly, what we call attribution, evidence attributing the thing of value that we have located and defined how it's held to either A, wrongdoing, or B, a wrongdoer. Key, or as a German lawyer would say, the Grundnorm, the spine on the back of an asset investigation, has to be to define the nature of the underlying obligation, the legal or equitable obligation that was violated, that was breached. Was it a breach of a contract, a personal obligation to repay under a personal guarantee or a promissory note owed to a bank, or was it a breach of fiduciary duty, a breach of trust, deceit, some other serious form of iniquity, public or private corruption? Because the remedies and our rights to know location, defining the manner of the holding, and gathering evidence of attribution of wealth to wrongdoing or wrongdoers is crucially, importantly, tied to the nature of the obligation that's breached. In this continuum of responsibility, the more benign breaches, oh, I owe a bank some money, I breached an obligation to repay, the banker's rights to recover or to investigate my assets are very limited, pre-judgment, and are more expanded post-judgment, whereas in the more serious forms of wrongdoing, breach of trust, corruption, iniquity, the law gives us far more accelerated powers of investigation at the beginning of a case and not the end.
Thanks. And so what you're basically saying is focus on the underlying claim, and one of the functions is find the asset or the money and repatriate it. That's not the only function of an asset investigation, and it's really critical that we define the others. Matt, maybe you can talk about one of the other functions that we look to use an asset investigation for, and why it has to be covert?
Thanks, Ed. As Martin says, it's the identification of the assets that we're all ultimately interested in, and that is the core of the inquiry. And while that remains the case, one of the other things that Martin referred to is to find the wrongdoer. And so as we think about the types of assets that we are looking for, the individuals are also an important asset to the investigation. And so in a fraud case, often the perpetrator is known, but in many cases they are not. Victims of fraud often don't know who has ultimately made off with their funds, and because they may only have dealt with an intermediary. And so one of the objects of the investigation needs to be identifying the perpetrators involved. And let me give you a couple of examples. For example, in internet-based scams where identities are stolen and identities of Fortune 500 company directors, for example, are used as the bait for fraudulent schemes. You as the victim, and you, frankly, as the person whose identity has been used, have no idea who the ultimate perpetrator is. Similarly, in a case that Martin and I have been involved in, of the perpetration of a false stock exchange scam. The Canadian connection in that case is actually not a person who would have received very much money, but is the IT person who put together the entire structure and is both able to identify how it works and where the assets ultimately are. And the third example, which you've heard Dan talk about earlier today, is who the ultimate beneficial owner is of various structures. And because you may know that there is a trust or that there's a limited partnership, but often there are those assets are held by nominees. And so identifying the ultimate beneficial owner is also an aim of the investigation.
Ruth, can you give us another basis for the investigation or an asset investigation using covert means?
Yeah, another function of the asset investigation is assessing the viability of a claim. So a victim may come to you and say, well, there was a commercial transaction set up, my money is supposed to be in this account, but now I'm getting some indicators that there may be a fraud. The guy's not returning my calls, there's a bounced check, the website's down, things of that nature. So you may think there's a fraud, and not know for sure, and there are ways to find out whether there is a claim there. There are court remedies that you can use, such as a disclosure order, which we'll probably talk about a bit more as we move on. But a disclosure order can be obtained, which would, for example, require a bank to tell you, is that money sitting in the account? If it's not, then you know you have likely have a fraud claim there. And if it is, maybe there's a misunderstanding. And when you're at that stage in the process, to get something like a disclosure order to assist with assessing the viability of a claim, it is a lower threshold, at least in Canada. You wouldn't have to establish a strong prima facie case of fraud at that point, because you're just trying to find out if there is a claim.
Thank you, Ruth. And then the fourth area that we identified as a potential reason to engage in an asset investigation or asset recovery investigation is a political objective. Many times in a corruption case, a client has a political objective. That does not mean that the underlying case is wrong-footed or is problematic. It can be, but many times governments have political objectives for bringing asset recovery cases, and you need to understand that at the very beginning of the case, because it changes the way you go about the case. You have to understand that your ability to work covertly is going to be undermined by the political objectives of the client on a regular basis. I worked on a case in Trinidad where the secret, confidential, stamped everywhere report from the forensic investigator one day after it was tendered to a government minister was on the front page of the Trinidad Express. And so you have to deal with that, and how are you going to deal with that? And you have to anticipate that the political objective is there, so they have a different matrix when they're making decisions about the asset recovery investigation. They are not going to necessarily be as concerned about the cost-benefit analysis as they are about their political objectives. So be aware, when you're in a case that has those overtones, they are going to definitely impact how you run your case. Now, that having been said, why are we doing it? What is the underlying case? One of the issues we confront is, what is an asset? And I think this is the one that frustrates me personally the most, because there is a common misperception in asset recovery cases, and it's built into and baked into the treaties that you see out there in a lot of the textbooks that touch upon and deal with asset recovery, and that is that there's this mythical bank account out there that you're going to be able to find and seize, and that's the end of the case. Well, that almost never happens. Defining what the asset is, defining how you're going to get the client's money back, or fill a hole in the balance sheet if you represent an office holder, or make your client whole or meet their political objective is critical. But you have to define what the asset is. So again, before we can launch it, before we can even design our covert mechanisms, we have to understand what we're going after. Martin, would you talk a little bit about how assets are hidden? And we'll start off with that, and then we'll come back to Matt and Ruth on the types of assets.
Thanks, Ed. The principle, what I like to say to clients is that the thing that's standing between you is as an aggrieved party, a claimant, a victim, so-called, a creditor. It could be a sovereign state, as Ed mentioned, in a public corruption setting, dictatorship, kleptocracy, is information. Only information stands between the victim and his money. And so the other side understands that. Paradoxically, they're faced with the problem. A thief knows only too well that he cannot give his money to another thief. So the lawbreaker must run to instruments of the law in a stable rule of law legal environment, so a contract means something. If value goes into a bank, that there's a contract of deposit that will be respected by the bank and enforceable by a local court. So the paradox that the other side faces, particularly in big money cases, $1 billion is hard to hide. It gets fragmented into multiple independent strands with independent structures in independent legal systems. But ultimately you find, in most of these cases, at the end point of value, represented by, could be hotel properties, operating businesses, stocks and bonds, in many of our cases, highly liquid antiquities or art, is going to be reposed in a place that's susceptible to legal remedy, therefore attacked by the creditor or the claimant. So the other side, recognizing this paradox and that they have to run to law to protect that which they've stolen wrongfully, also then really is dependent upon secrecy and concealment and causing information to be suppressed through fragmentation of data across national boundaries and layering of multiple legal entities, and the use of, the expressions nominee UBO. This is a new technique. We have UBOs. Everyone's supposed to be collecting the ultimate beneficial owner data behind a structure, correct? But now we find for $4,000 or $5,000 a year, some folks in the structuring business will lend their name as dummies, adjuncts, strawmen, frontmen in order to conceal, again, the information relating to wealth that rightfully belongs to someone else, because the debtor doesn't want the creditor to know where it is. That's his principal technique of holding the value.
Great, thank you, Martin. Ruth, if you could talk us through one of the main areas that we look at with regard to what type of asset we're trying to recover, if you will, and the one that's not really obvious is third-party claims. Is that how does that fit into the overall structure of designing the covert asset recovery scheme?
Well, it's I think almost always part of that strategy. So as you said, Ed, you can't just look to see if there's some account with frozen funds, because often those funds, the proceeds of the fraud have been dissipated. They're difficult to find. But the third-party claims is an important avenue of potential recovery for victims. So, for instance, you have I'll give you an example. If the fraud itself sort of originated in a fake loan transaction and there were lawyers involved in setting up the loan transactions and bankers involved, you can look to those parties and there's potential claims against them. For example, if the purported loan transaction involved money that was supposed to be locked in an account and the victims had a lawyer at the time who papered the whole transaction, if the money disappeared, then you can look to that. Did that lawyer fall below the standard of care that he should have taken? And is there a claim for negligence against that lawyer? Now, on these third-party claims, just one important point is timing, because you can't sort of chase the proceeds of fraud and then later think, well, maybe we should look at third-party claims, because you have to think about limitation period issues. So you really have to do this at the outset, identify what other claims there are. And I guess just one other point on third-party claims, once you get into the investigation, you might see that the wrongdoer made payments out to some victims and not to others. So another third-party claim is potentially clawing back some of the payments to bring them back to the kitty to be distributed on a more equal basis. But again, that has to be done early on as well.
Great, thank you, Ruth. Matt, walk us through the issue with regard to hard assets, which is the one I think people are most familiar with, but actually one of the hardest ones.
Well, and as Martin says, it remains the core of the inquiry is to reach out and to attach those assets. Although the claims that Ruth described for you can also retain a significant amount of value. I won't spend a lot of time on the hard assets piece, because it is all of the things that you would expect it to be. It's real property, whether that's personal, commercial, or industrial. It's bank accounts, it's debt instruments, it's chattels of every kind, all the trappings of wealth that you would anticipate, be it cars, boats, aircraft, jewelry, fine art collections, and the like. But perhaps most interesting and part of the unraveling of the fraudsters' structure is the ownership interests that one piece of the fraudster organization has in other components. And I'm talking about other corporations, related corporations or trusts or limited partnerships. And it's through the affiliation of those holders that we are going to try and trap not only the value that's held in the name of the principal fraudster, but also the organizations of which he or she is the ultimate beneficial owner. And one characteristic of that investigation is the proceeds. So no matter how the initial corpus of the theft or the actual money, how it has been transformed in one form or another, the ownership interest of the victim remains. And so we're looking at it in all of its forms and all of its proceeds.
One of the first questions you get confronted with when you do this is usually from a judge. And she will ask you, why do you need this to be secret? Why do you have to do this in secrecy? That's not normal. And you have to really carry a heavy burden when you're asking a judge to allow you to do what we try to do. And we're going to come on to the how to, but we want to first explore the why of secrecy, because it may seem obvious to you, as many of you here do this for a living, but you have to explain it to somebody at some point. You have to explain it to a judge, and you have to convince and persuade that judge to let you do something that is not the norm. So Matt, why don't you pick up that issue?
Sure. So let me frame the issue this way, and then I think that the panel members will all give you examples where this has been that they have encountered where secrecy becomes very necessary. And in my view, in order to understand the need for secrecy, you have to understand the position that the victim is in at the outset of a case. And of course, secrecy becomes quite controversial, because once assets are frozen and the like, there's much outrage on the part of the fraudster to say, well, you did this in secret, how dare you? How dare you use secret court processes to trap what I say belongs to me? And so to understand the need for secrecy, typically the fraudster holds all of the cards when you start a case like this. It is not a level playing field. The fraudster knows exactly how the scam has worked and who's involved and where the money is. And the victim knows almost none of that. The victim knows that the money's gone. He or she might know who has taken at least part of it. and he or she knows that, or has just learned that the paper that they hold is effectively worthless. And so secrecy in the early stages of that investigation is critical for a number of different reasons. First of all, and fundamentally, if the fraudsters see you coming, those assets will move. And you heard Dan talking earlier about how at the click of a mouse, money moves internationally now, and if you cannot operate in secret, and if you cannot operate under judicially supervised investigative steps that are gagged and sealed from disclosure, then the assets will move, and you will be left in a situation, not unlike our last presenters, of fighting long litigation with your own money being used to fund that litigation against you. And so two other fundamental truths exist and support the need for secrecy. And the first is that we, as the investigating lawyers and as the victims, can't do everything that we need to do. We can't get the information that Martin talks about without help from third parties. And we can't have those third parties telling the fraudster what we're doing. And thirdly, we need time. We need time to put the pieces of the puzzle together that the fraudster already understands, and so we need the cover of secrecy in order to do that, in order to assure that we're in a position to separate the fraudster from the victim's money and to level the playing field and to have that fair fight. And that's true in the investigation that is conducted, that's true for court actions that are undertaken, that is true for the courtroom itself. When you are making these applications. In one case that I was involved in, and then Ed, I'll hand the microphone back to you, in Manitoba, we were all set and ready to get our investigative orders. We were in front of the judge. We had binders and binders full of evidence against the fraudster who was still employed by the bank that I was representing at the time, and we were operating in secret. And into the courtroom, as I'm about to stand up and make the application, is the person known to be the fraudster's lawyer, who's there on a completely unrelated matter to make an application. And so even the sealing of the courtroom when you're making the application is crucial to preserve the integrity of the investigation until you are ready.
That's one of those aw shucks moments when you just can't believe that it's happening. Bad luck. Ruth, would you walk us through some of the reasons that you've seen why secrecy is critical, especially in early days in these types of cases?
Sure. It really picks up on what Matt is saying. You know, I had a case that involved, it was a large mortgage fraud, so the victims thought their money was being invested in mortgages. And through their sort of preliminary investigations, we were able to see, well, the mortgages have been transferred out to some third parties. We don't know who's part of the, you know, who's a wrongdoer, and we need time. So we get a disclosure order from the court and requiring various institutions, banks, mortgage brokers to give us some information, all with a view to identifying who are the wrongdoers, and then ultimately what we'd want to do is freeze their assets. Now, in that first step, getting the disclosure order, we had to have a gag and seal order. Otherwise, if the initial wrongdoer, we know of one, we don't know if there are others, we think there are, if one of them knows, then they're all going to know, and they're all going to dissipate their assets. And this process can take a bit of time because, for example, when you're getting a disclosure order which requires a third party to give you some information, and when you're trying to identify the wrongdoer, it takes a bit of time. It's not always overnight. It can be a couple weeks that pass, which is a lot of time for wrongdoers to figure out where to hide their assets. Even one day can be enough time for them. So it's critical, and as we went through each of the steps in that case, it was we wouldn't have been able to get to where we ultimately got to, which was being able to freeze some assets without the gag and seal order in place for the first few steps.
Yeah, and this is so critical. How you go about those first couple of steps really will ultimately determine the outcome of the case. You can really do serious damage to your case at the very beginning. In a case that we're handling here in Miami out of Brazil, which is now unsealed, and it's a real seal, unlike what you heard about in the last panel, the case had been sealed not only in Brazil but in other jurisdictions. So when we went into court, if we didn't get the seal, we were not going to just blow our own investigation. We were going to blow investigations in 3 or 4 other jurisdictions. So the tension was high. The burden was high. We were able to draw on really two main factors to prevail. One was a good job of laying out the reasons why and the evidence that we had, the underlying criminal activity, the underlying fraud. And the second was credibility with the court. We had been in front of this judge many times before. We had earned her trust and respect. She knew that we weren't going to lead her astray or lead her to error. And that's critical. When you're going into jurisdictions, you have to find counsel that have that kind of rapport with a judge, with the court. You don't know which judge you're going to get, but you can pick your lawyer. And your lawyer, he or she, has to have that level of credibility, because there is a certain amount of trust involved in a judge giving you the ability to go around and go into someone's underwear drawer without telling them that you're going in their underwear drawer. And because it's not natural, it's not normal, it's not something that we generally allow to happen in litigation, especially in this country where we have a very transparent, open legal system where people know what's coming and there's advance notice, and it's very rare that you're able to operate in an opaque manner. So Martin, why don't you take us through another example where this has been critical to the success of the case.
Thanks, Ed. The close cousin to a seal and gag order or its justification, which we would say, if the defendant learns of the progress of an asset recovery inquiry, he will undoubtedly take evasive action. This is a hard thing to show a judge in an objective sense, because what we're doing is projecting forward what might happen in the future. It hasn't happened yet, in a sense that it's just like the close cousin to this problem is trying to get a freeze order. In English law, we have to show a good arguable case on the merits that someone A owes money to B, but also that A proposes an asset flight risk. How do we show that? How do we show that someone prospectively will fly away with their assets? Well, it's the same story with a seal and gag order, because we're justifying secrecy orders by virtue of the risk of asset flight. So the freeze order remedy is very a close cousin in terms of its underlying legal analytical structure or architecture to a seal and a gag. And we're going to get into more of the theory later, particularly in the area of balancing the prejudice to the two sides, because it's key to getting these remedies that the judge be comfortable that we're balancing convenience and prejudice. That's what injunction law is all about. Now, I'm going to just give you a very quick example of a real-life case which demonstrates objectively what happens if there's a busting open of the seal or the secrecy that attends one of these investigations. For 18 months, my firm acted for a hedge fund that had been victimized in a $25 million fraud. Before we were engaged, actually, the client had obtained a judgment against the primary wrongdoer. The wrongdoer had sequestered his assets in a way which was highly complex, involved offshore trusts in the Cook Islands, Nevis, very valuable art locked away in vaults. But we discovered he also had a valuable business here in the state of Florida that he'd sold to a French company, and we were able to secretly, with seal and gag and disclosure orders, sneak up on him, gather over 2 million confidential records from multiple jurisdictions with the assistance of 5 judges. It was a tremendous effort, and we reached the climax to appoint or seek the appointment in the state of court system in Florida and Sarasota of a receiver to hold the assets, preserve them on an interim basis, pending the outcome of the judgment enforcement case to be brought against an array of asset holding vehicles that we could prove conclusively, we thought, were linked to your judgment debtor. And so our local council in Sarasota had one of their clerks drive to the courthouse one day, the application papers, which bore the fruit of all this effort, and of course had sealed the box with big red print saying, "By order of the judge, this box of records are sealed and must be given only to the judge for the judge's eyes only." And the critical mistake made was this young lad in the law firm locally simply trusted that the registry would understand what that meant. And it didn't. Unfortunately, the registry obeyed or behaved robotically, handed the box over to what they call the web page clerk, because in Sarasota at the time, all pleadings that come in to the system get scanned by the $10 an hour web page clerk, who I guess is not capable of reading the red warning caution on the box, and onto the website of the courthouse came all of our secret papers, and coincidentally, the fraudster had some trigger points about you can buy these or access to search engines that trigger your name whenever it gets filed in a courthouse anywhere, and the debtor knew immediately what had been filed, could print up all of our secret evidence and the fruits of our efforts, and all the money that we are about to freeze, over $20 million of cash in banks in Florida, we just disintegrated and blew apart into multiple pieces before we could get at it. And it destroyed $2 million worth of investigations. That proves the case that, at least in the area we work in, secrecy is crucial, and there could be complete destruction of our work through a leak.
Notwithstanding Martin pointing at me 3 times during that presentation, that was not my firm that did that. I want to be very clear. Very important. So now we're going to move on to asset recovery tools, and this is where the rubber meets the road. What can you actually use? What's the methodologies? And really, the first one, and the one that we start with always, is for the most part, is extrajudicial tools. And I'd like Martin to take us through some of the extrajudicial tools that are available to all of you right from the get-go, without having necessarily to even hire a lawyer.
Well, the first thing is data that's available in the internet. So, and that's a secret form of investigation. We can have a trained professional who knows how to gain access to publicly available information on the internet at levels of analysis and access that are much deeper than untrained professionals may have awareness of. There's a specialist trainer in New Jersey called Cynthia Hetherington, and she puts on a great show. She trains everyone from officials at the CIA to bank compliance professionals on how to really sweat the internet for information, how to gain access to data that you don't have any idea may be there. She can go back in time and reconstruct what data was like in 1993, for instance, in a red flag type scenario when you sue a bank wanting to prove that in 1993 the bank may have had access to certain publicly available data that would be a red flag that might found a lawsuit against the bank for assistance in the fraud. We have also proprietary databases that all decent investigators will sign up to and pay a monthly fee or stipend for access to, and that can dump massive amounts of data about a subject. So we essentially, let's see what's in the newspapers electronically, what's in court filings, what is the history of the subject in social media, and let's build a profile in the beginning phase of the case. It doesn't cost that much money. We're talking $10,000 or $20,000 in a major case just to get the public data at beginning a profile of who we're dealing with today. And then we'll look at using surveillance, perhaps sting operations in a very sophisticated way in big money cases where we might present ourselves through an agent trained to pretend to be a prospective victim or a prospective collaborator in fraud who might be wearing, in a place that's lawful to do so, a secret tape recording device in order to get inculpatory statements recorded so judges can actually hear the voice of the fraudster laughing about victims or chuckling about his exploits. There are an array of Dick Tracy techniques that we use with professional former law enforcement officials who run the investigations outside of the court under our supervision. We have to make sure that we ask 3 questions in these kinds of matters. 1, is the investigative measure about to be undertaken by our investigators lawful in the place where we're going to undertake it? 2, will the evidence that be obtained from it be admissible or useful in the jurisdictions that we need to adduce it in? And 3, is it legally, professionally, ethically proper for a lawyer to cause it to be done? Those are the 3 crucial questions.
Yeah, and look, a good investigator, a well-trained investigator will make your case. A bad investigator will not only destroy your case, but will get you and your clients sued. So it's really important to make sure that you're working with people that are vetted and know what they're doing. The other thing, just to pile on one for 10 seconds on what Martin said, on the social media part of it is really critical, because your target might be very careful about what he does on social media, but his kid isn't. So if his kid puts a picture on saying, here's a picture of me fishing on Dad's fishing yacht in the Bahamas this weekend, you're like, oh, Dad has a fishing yacht in the Bahamas. Now we know one asset. And the guy is very careful not to be on Facebook, but his kid isn't, or his wife isn't, or vice versa. You know, look at other people, and that's you have to design your investigative phase when you're looking at social media now, because it is so critical. Very, very, very powerful methodology of acquiring information.
I forgot to mention Black Forest runs, Ed.
Yeah, or we call that garbacology or dumpster diving, going into people's garbage cans, whether commercially or on a individual or personal basis. Here in Florida, you can do that under certain circumstances. Again, if you do it wrong, you're going to get sued. If you do it right, you're going to get a treasure trove of information and a bunch of eggshells and coffee grinds and other things, too, that go with it. Ruth, would you walk us? Now we're going to go to court, and we're going to have to go into court in the jurisdiction where we want to operate. What judicial tools are available to us that would allow us to start gathering this information, hopefully on a secret level?
Well, I think the one that I've referred to before is the disclosure order, also called the Norwich Pharmacal Order. In short, what this is it's an order requiring a third party who's somehow involved, innocent or otherwise, to disclose information. So an obvious example, and the one that comes up a lot, is banks. So you want to know, who the wrongdoer is, but you want to know what money is in his accounts and where it's gone. So you can obtain an order requiring that bank to provide you with the information. And this is still ideally, you're also getting that seal and gag order, so the bank is not entitled to disclose the existence of the order and their compliance with the order to the wrongdoer. Otherwise, the investigation is immediately compromised. So that's a key one in the asset investigation, and it's helpful in that it's still it's confidential from the wrongdoer. Another one is an Anton Pillar order, and that sometimes people refer to it as a search warrant. It's not a search warrant in the sense that it entitles you to enter premises and search them. What it is, it's an order that requires the defendant, so the alleged wrongdoer, to provide access to his premises, and you'd obtain it based on evidence that you think you have reason to believe this wrongdoer has incriminating evidence in his possession, and it might otherwise be destroyed if you don't get this order. So I guess the downside about that is, depending on where you are in the investigation, the jig is up, right? I mean, once you get that order and you enforce it, well, now the defendant, the wrongdoer, knows he's the target of an investigation. So if you haven't gathered other useful information as to his assets, you might have given him a heads-up notice a bit too early. Now, sometimes another tool that can be used is a court-appointed officer is able to conduct examinations, investigations on a confidential basis, and that can be quite a helpful tool. And I think those, in terms of the judicial tools, that covers the main ones.
Great. So that's if you're in the jurisdiction typically where you're operating. But many times the information you need is abroad. And by abroad, meaning somewhere other than where your feet are at the moment you say it. Because we always think of abroad as, at least the U.S. lawyers think of abroad as outside the United States. But really, most of these cases start outside the United States. But the evidence is in the United States. How can you get that information? Well, there's one very, very powerful tool called 28 U.S.C. 1782. That's a U.S. Code section that allows you, if you have an action on foot or you reasonably contemplate bringing one, you don't even have to have one pending. You have to reasonably contemplate bringing one. Can bring a claim in federal court in the United States to obtain evidence, actual record evidence, depositions that are sworn statements under oath. You can compel the person to come, and other kinds of evidence that is legally obtainable in the United States. So that is a super powerful tool. So sometimes a U.S. lawyer will automatically rule that out because they think, well, I'm in the U.S., I can't use it. But if your case is really somewhere else, or can be grounded somewhere else, you can use 1782 as a tool to come into the United States and gather up that evidence in anticipation of the claim. And the very tools that Ruth just talked about are also deployable in other jurisdictions, especially the English Commonwealth jurisdictions. In the civil law jurisdictions, which tend to have many similar tools, even though they might go by different names, you can get discovery, even pre-suit discovery. Don't let a lawyer in say, Panama tell you they can't get information in advance of a case. They can. They have a thing called a prueba anticipada. They have another thing called an acción exhibitoria. They can bring actions to get information. Now, that's just because that lawyer's never done it. And we call those lawyers Dr. No, because they tell you all the things you can't do. You ask them, can you do that? No. Can you do that? No. Well, we really want lawyers who are going to tell us what we can do. And so we've learned over the years by kissing a lot of frogs, most of which don't turn into princes, but some do, that these folks know what they're doing, and we work with the princes, and they ultimately can get you information. So it's important to try to think about this almost like a three-dimensional game or a Rubik's Cube. You really have to go many times offshore and obtain that information, and it can be done in a secret way too. And we'll come on to the secrecy level and how you keep it secret in just a moment. But one of the other tools that Ruth alluded to was an office holder. And one of the very, very powerful tools that we use, and Matt also mentioned it, and that is that one of the things you might have access to is the stock of a corporation, which leads you to, inevitably, insolvency or bankruptcy. Matt, walk us through some of the ways you can use bankruptcy or insolvency to obtain assets or information about hidden assets, whether it be covertly or not, and then we'll talk about the covert nature of it.
So a couple of different aspects. First, I'll say a few things about some of the tools that are available in bankruptcy, and then I think we'll talk about different platforms that we can use, bankruptcy being one of them, to realize the assets of the fraudsters organization. And so, bankruptcy is, as Ed says, is a very powerful and effective tool to effect recovery, and probably the most important reason for that is that the trustee in bankruptcy stands in the shoes of the bankrupt, of the fraudster, and so he or she takes control of the ownership and the affairs of the bankrupt entity or the individual. So that the actions taken by the trustee are really those of the owner, of the bankrupt themselves. You're entitled to the bankrupt's information, and you're entitled to the bankrupt's property. And that's an extremely powerful tool, because you're no longer a stranger to the assets. You're no longer a stranger to the proceeds of the fraud. You are actually placed in control of them. And let me give you an example when it comes to, for example, privileged records, because whether it was Dan who was talking about it earlier or others here in this panel today, lawyers are often involved, knowingly or otherwise, in as structurers of the fraudster's empire, of the fraudster's holdings. And typically, as a stranger to the assets, you're not going to be entitled to that privileged information. You can try, and it is possible with a great deal of effort to get at those records in different ways, but it is uncontroversial that the owner of the asset is entitled to that privileged information. And so when you stand in the shoes of the fraudster, it is a relatively uncontroversial and easy task to go to the lawyers and say, but I am now the office holder, and you must explain that structure to me, which is what starts to unravel all of the pieces, those limited partnerships that we talked about, the trust structures and the corporate structures that we talked about earlier. In addition to that, when the fraudster does see the investigation coming and assets move because he or she doesn't want those assets in the estate any longer, there are avoidance actions, preference actions, and reviewable transactions. In other words, most of the bankruptcy codes around the world will provide for voidable transactions to be voided or voidable when they have the effect of preferring or moving assets out of the estate without value within a certain prescribed time frame, and that can be a very powerful tool for regathering value to the estate and realizing it for the victims. And thirdly, the trustee has very broad powers of discovery. Anyone associated with information around the bankrupt estate or the assets themselves can be examined and can be examined on very short notice so that the trustee is in a position to quickly identify and move to preserve value on the part of the victims. Those are the tools. So let's talk about, as the slide says, foundational issues and picking the right platform for the battle. And let's talk firstly about bankruptcy, since we're on that topic. There are a lot of advantages to a bankruptcy as a platform to do this. The first is that you're court sanctioned and court supervised. You're a court officer with ready access to judicial assistance to the extent that you require it, which creates both legitimacy and authority. The trustee displaces the dishonest and untrustworthy custodian and replaces that person with bonded, professional, and honest management. Again, standing in the shoes of the fraudster, which can both be a good and a bad thing, and I'll come to that in a moment. Next, it's federal in reach, and so at least in the U.S. and Canadian context, I don't have to start ancillary proceedings wherever I find assets around the country or around North America. I am in a position to reach out and to attach those assets within the country in which the bankruptcy has begun. Under the new ancestral model law, relatively new, being adopted by more and more countries around the world, and this is a gross oversimplification that we could spend half the day talking about. There are common rules for the administration of bankrupt estates, and so more and more we're in a position through the bankruptcy platform to reach out internationally in a single bankruptcy with a single office holder and to harvest value in a way that sees local creditors treated fairly and predictably. And that allows for relatively easy international recognition. There are some downsides, and I should say just before I get to that, that as the trustee works through all of that information and those information sources, and it becomes clear who the ultimate beneficial owner of the various of the trusts and limited partnerships, et cetera, as that becomes clear, then those assets fall under the same administration with the assistance of the courts. So there are some disadvantages as well. It's a very, very powerful platform, but it can be difficult to conduct the bankruptcy itself in a secret way. All of our presentation is obviously geared towards secrecy, and once you're in bankruptcy, there are many ways that and tools that you can use to act with court sanction and to maintain that cloak of secrecy, but you probably have to break cover in order to file the initial petition, in order to get into bankruptcy in the first place. So the biggest hurdle can often be getting to bankruptcy in the first place. And the second is the notion of, that I know gets some play, especially in North America, of the notion of in peri delicto. So if I am standing in the shoes of the fraudster, and if I am therefore cloaked with whatever actions the fraudster has undertaken, there are some actions which will not be available to me. I'm not going to be able to sue my co-fraudsters for recovery. And so there are some actions that when you design the recovery platform and you coordinate the steps that you are going to take, that you may want to reserve to the victims as opposed to the trustee.
Matt, although bankruptcy, you're right, involves open justice and no secrecy to have a bankruptcy trial and have a trustee appointed, what about a provisional liquidator or an interim receiver, like in the case we worked on in the late 90s?
You bet. Martin and I were involved in a case in which, for I believe the first time, a Canadian court appointed an interim receiver over an individual and did that effectively in secret, the individual being in prison at the time, and allowed for a period, I believe it was of 60 days, Martin, to allow the interim receiver to act covertly with court approval.
And remember, Matt, we got, I think, 6 or 8 foreign requests for assistance under seal and gag as well, where the Supreme Court of British Columbia issued 6 to 8 extraordinary requests under seal abroad to countries around the world, asking that the interim receiver, your client, be recognized secretly in his interim office to locate and preserve value.
But ultimately, that petition on which the interim receivership is based is going to come to light, and we were able to obtain 60 days. So that started the clock running in a big way to cover as much ground as we possibly could and to achieve as much of freezing of assets as we possibly could within the 60-day time frame.
Although you had to be neutral because you were counsel to the neutral receiver.
Which, of course, I was.
The one topic I want to hit very quickly on this area, and I won't take the full time allotted to me because we're going to run a little long if I do, is when should you and when should you resort to the criminal process? We talk a lot about the civil side of this, but really this is a combined arms approach. You really have to think, what can I use to get the client's money back? And the criminal process, you have to think about the criminal process both in the common law perspective and in the civil law perspective, because those are the two dominant legal schemes that exist in the world today. In the common law perspective, I think most of us in this room have had the experience of seeing the common law system fall woefully short when it comes to restitution to victims. If I had, $10 for every victim that has come to me and said, well, that's an interesting approach you have there, but the FBI is going to get my money back. Yeah, right. And then if I had $10 for every one of them that came back to me, I wouldn't be sitting in this chair, because while the FBI is an excellent organization and prosecutors are really hardworking and I have nothing but respect for them, they're not really equipped to do this. They don't really have the resources to do it. It's not their primary function. Their primary function is to put people in jail. Now, our system has the victims' rights statute that has come out, but in fact, I think even the folks that are going to be open and honest about the criminal system, who are in the criminal system, will tell you it's just not. It's a very blunt tool to try to get restitution for a victim. It can work sometimes, but it probably works maybe 10% of the time. But in the civil law world, it is the predominant way to get money for your client. You really have to open your mind to the idea that in the other legal culture, you have to understand how that legal culture works, and to use, if to go to the Dominican Republic or another Latin country, you want to be thinking about using a querella or denuncia, or we have a German lawyer, a Strafensaga in Germany or Austria, or a plainte penal in Geneva or in France, because those tools allow you as a victim and a victim's counsel to participate in the criminal process to a degree that as a common law lawyer we would never be allowed. We would never have access to the investigation, the fruits of the investigation, the possibility of getting damages from the criminal matter. That's not available in the common law world. So you have to think when you're, one of my good friends here from Brazil, we have the same methodology we use in Brazil. So it's very, very important that you suit your asset recovery plan to the jurisdiction in which you believe the assets are likely to be found, and use criminal. Do not rule criminal out. It is a very, very important part of the equation when used properly. But that all having been said, the predominant process that I certainly think works the best in asset recovery is the civil process. And in that regard, Ruth, maybe you can walk us through some of the devices that are available to seize and lock up assets on the front end of a case, which is really critical because it creates a war chest for yourself. It manages risks, allows you to fund the case, and it cuts off the bad guy from his war chest as well.
Sure. The one that most people are familiar with is the Mareva, which is a freezing order, and you can freeze the assets of the wrongdoer pending further order of the court or pending the disposition of the proceeding. And that is, if you have a bank account with money sitting in it, that's obviously quite a good one. If you have land, however, there's another way of sort of effectively freezing the land. We call it a certificate of pending litigation. So essentially, and it might be called different things in different jurisdictions, but essentially it just puts a notation on title so that it makes it almost impossible to deal with the land. Any third party who wants to buy that land buys it subject to what the disposition is in the proceeding. So effectively, no one's going to buy the land. Now, however, sometimes you have land and you don't want it to sit pending disposition of the proceeding because it could take years, and this might be a particularly good time for the land to be sold for the victims. So, to freeze the asset doesn't do you much good because it might be sitting there for years and might diminish in value. In that case, often a receiver or a court-appointed officer is quite useful because the court-appointed officer can be authorized to take possession of the assets and deal with them, subject to further order of the court, in a way that is most beneficial to the victim. So, for instance, it might be that the land needs some development, and that it might be that the land should be sold now because this is estimated to be the best value for it at the time. And so you could get a further court order allowing the court officer to sell the land and hold the proceeds from that sale pending disposition of the proceeding. In picking up on some of the things Matt said about bankruptcy, a court-appointed officer outside of bankruptcy can do some of the same things in terms of, and I mentioned it before, sort of clawing back payment that the wrongdoer may have made to third parties, whether they be other victims or to family members, but it can be critical in looking at the transactions that the wrongdoer engaged in to try and claw back the value, and you need to do that quickly. So a court-appointed officer can do that in the same way that a trustee in bankruptcy can. It's just done pursuant to common law and sometimes statutes that have been enacted to basically reflect the common law. But in common law jurisdictions, there is good authority for clawing back.
You mean like in a net winner case, if someone wins money in a Ponzi scheme, Ruth?
Yes, that's exactly it. So
you end up suing a so-called victim.
Well, because you can have victim 1 gets a major payout, gets 200% on their investment, and victim 2 is getting 0.
We're working on a major case right now, Ed and I, where it's pretty clear in the Ponzi scheme setting, everyone accepts that you should be able to sue net winners because they're not economic victims, they won in the game of the fraud. Obviously, usually innocently. And they're upset because they've won this profit, and why are you taking it away from me? Well, because it was a fraud, and we need to be equitable and try and balance the books and recover money for net losers. Controversially, Ralph Janvey, an SEC receiver in the Stanford case, sued a bunch of net losers on the theory that near the deepening zone of insolvency in Stanford, when it was close to collapsing, there was sort of a run on the bank post-Lehman Brothers September 08, or certainly post-discovery of Madoff on December 5th of 08. I think Stanford collapsed in February 1909. So in that run on the bank period, the theory is, well, a grandmother sitting uncritically, not looking at the markets in Mexico City, who has $20 million invested in Stanford, she doesn't understand there's a run on the bank. She's just sitting there, and her money's sitting in Stanford, whereas perhaps people with greater acumen who follow the market will run at the bank and get some money out. Is it equitable and fair to the little old lady that she's not as aware of the risks, or is she being unfairly prejudiced by smarter people and faster people? So this theory was developed. Janvey got slapped down by the Fifth Circuit. But I think that the theory is still worthy of an attempt, a test case like in the Caribbean, and I think we're going to be running one soon.
Yep, and so let's go into how do you keep this secret, which is our last topic of this, because we've talked to you about why you do it, understanding what assets you're going after, what's the underlying reason for secrecy, what are the tools that you can use, but how do you keep it secret? What is the methodology that you use to sort of create that cloaking device that allows you to move around and get information until you're ready to come out and pounce on the fraudster or the fraudster's assets? And Ruth, why don't you kick us off with a discussion about how this is dealt with in Canada?
Well, typically we referred to seal and gag orders, so we would get orders, either sealing the court file, gagging others, preventing third parties from being able to discuss either the disclosure order that they've been have to comply with, and things of that nature. Now, I guess there's a distinction in various jurisdictions, because in Canada, at least our courts have described this type of order as typical and justified. And the courts have made statements along the lines of, well, our disclosure order to assist you with this fraud investigation won't be effective unless we give you the seal and gag order. So they just grant it. It seems, and they're just sort of one-line throwaways in the cases about, of course we're going to do this. But I think that in other jurisdictions that seems to vary.
Matt, maybe you can talk a little bit about a particular case in Canada where this, because it's not the case in the United States that it's typical.
Sure. So in Canada, since about the mid-1990s, when the Supreme Court came out with a case called Dagenet about publication bans, the courts in various provinces have been promulgating rules talking about what you have to do in order to get a publication ban or a secrecy order. And they've gone so far, certainly in one jurisdiction, as to say anytime you want a secrecy order, no problem, you just let the press know that you're looking for one, and then they can come and they can argue the contrary. And those rules now exist in virtually every Canadian jurisdiction. But the reality is that in these cases, that would be complete anathema to the type of remedy that you are looking for. And when that argument was made in a case in Alberta, where effectively the defendants, having been served with a number now of these disclosure orders and the like, once the investigation has come to light in a planned way, went to the court and said, "My lord, there's no way that you can do this ex parte without notice to us. It has to be done on the basis of a full hearing up front," which is exactly what the criminal bar used to argue about search warrants. And what the judge said is, in effect, that would be exactly like inviting the accused to the hearing for a search warrant. And there is no way, except in the case of the stupidest possible criminals, that is going to ever work. And so, as a result, it's an extension of the court's inherent jurisdiction to regulate and control its own process and to make its own orders effective. And it really is not controversial in Canada as a result that this kind of secrecy is imposed as a matter of course.
It is the exact opposite in the United States. It is the exception, not the rule. In Florida, for example, the Constitution specifically has a provision that you have the right to financial privacy. So automatically you're asking the judge to violate someone's constitutional right to allow you to go into their bank account and look at it without them knowing about it and telling the bank, you can't tell them that I'm going to be looking in their bank account. It's a very, very steep hurdle and burden to overcome. And we've been able to analogize it over the years, as Martin and I have discussed, to sort of family law cases or patent law cases or trade secret cases where, you know, if you don't protect this information, the value of the case will be zero. And you'd be surprised. There's still some judges. I've been speaking at this conference for 9 years, and if we had this and we did have this very topic 8 or 9 years ago, and my response sitting in this very podium was, you can't do it. The good news is you can do it now. Over the last 8 or 9 years, there's been an evolution in thinking. Judges have become more sophisticated. They've seen these huge, humongous frauds that have impacted thousands and tens of thousands of people, and judges have started to open their minds to the possibility that we have to allow the process within their inherent jurisdiction, as Matt says, to get a head start, to level the playing field, because if you don't, the fraudster's always going to be 1 or 2 or 3 steps ahead of you because of how quickly they can move assets or encumber assets that they have and move the value offshore.
I would just say that it's amazing to me that there's such little developed case law in probably the most crucially important remedy, which is, Ruth said, is almost an afterthought in many sophisticated common law jurisdictions like Canada, where there's thrown into a judgment is one line. Well, of course we can give a seal and gag. Of course it's in our inherent jurisdiction, which always makes me nervous when a judge that has no other basis for an order other than it's, quote, in his inherent jurisdiction. Of course, we understand that in order for the order to get information about assets in the context of a fraud case to be effective, we have to guard against the risk of the defendant taking evasive action. But I say that, sort of in a pure academic sense, this very, very important tool is at risk of being undermined, because what we're doing when we're asking for seals and gags is we're suspending the right to open justice, we're suspending the rights of due process to the other side, we're asking for effectively an anti-privacy law order, an anti-data protection order. We are stretching the boundaries of fairness and justice when we're running around the world for 2 years, gathering 2 million records that are all confidential and private, and they're better not be misused by our team, disclosed to the New York Times, or in any other way demolishing the fabric and justification and integrity of what we're doing. So this is a very, very delicate and important area, and if a group of us begin to mess it up, or visit criticism on the use of these very powerful yet delicate tools, because of what we're doing, we're stretching the boundaries of fairness so far that we could well be opening ourselves up to criticism and then depriving victims of rights of recovery if we mess up the fabric of the law and its development in this very, very crucial area.
I want to thank David Marchant for letting us address this very important topic, and please help me in thanking the panel for an excellent job. I think it's a coffee break now.